We have some breaking news we want to share to you. This coming from Idaho, in particular Fremont County, Idaho, where we have learned that the court is recognizing that Lori Vallow Daybell has been restored to competency. Remember, we told you how she was deemed incompetent, meaning unfit to stand trial. Well, now her competency has been restored. This means her case can proceed to trial. So we have an order the court just issued on this, saying in part, quote, based upon the court's determination that defendant Lori Vallow Daybell is restored to competency and is fit to proceed, the court orders that the defendant be brought before this court to be arraigned. So what's going to happen is she's going to be transferred from the custody, if you will, of the Idaho Department of Health and Welfare. That's where she's been since she's been deemed incompetent, to now the Fremont County Sheriff's Department. So she will go back to the local jail there in Fremont County, Idaho, and then be brought in front of the trial judge for arraignment on April the 19th, 1 p.m. Eastern time is when we understand this is going to happen. And of course, we're going to be following that arraignment. We will be there for all of it as we've been trial tracking this case since the inception, really before she was even charged, since her children went missing. We know that is what she's accused of. She's accused of the deaths of her kids, JJ Vallow and Tylee Ryan, her two children that went missing while she was off in Hawaii with her husband, Chad Daybell. His wife, Tammy Daybell, is also someone she's accused of helping to kill. We know she is charged as a co-conspirator with her husband, Chad Daybell, who was a religious leader. She's been given that nickname Cult Mom because she became a follower of his teachings, and then the two became romantically involved in all of the deaths. Very, very, very suspicious. This is quite an ugly case. It's set to go in January, and we know Chad's case has been proceeding all this time while hers has been kind of lingering in the court system. Well, now there will be time for it to catch up. In these cases are joined. Remember, he was trying to have his case severed from hers. They're going to be joined. So we know January of 2023 is when they are supposed to go. But this is huge news today as her competency has been restored. I want to bring in now for a little bit of discussion criminal defense attorney and former prosecutor Daryl Cohen. He's standing by in Atlanta. Daryl, I know we have to go back to the New Jersey case, and I thought a perfect segue to go back to that one would be to ask you to kind of help us understand a couple things here. Here in the Vallow case, we've got the competency issue, right? The inquiry as to how she is here and now ready to stand trial. But in the Barrasone case in New Jersey, the jury has to do a backward-looking inquiry, right? To his mental state at the time of the incident, whether he was insane or not at the time the crime occurred. Would you talk to us about the differences there, please?
Well, Julie, let's go to the Vallow case, or Cult Mom. This is, does she understand right from wrong? And if that's the case and the courts have deemed that she does, then she can go to trial and be found guilty or not guilty, or heaven forbid, a mistrial. Going now back to New Jersey, the court is trying to determine, or the jury is trying to determine, did he understand when he committed this crime of trying to kill? Did he understand right from wrong at the time? And the prosecutor has done a very meticulous, though rather boring, job of bringing that to the jury. So the jury has to decide, did the defendant, did he know right from wrong at the time he tried to kill these people? If he did, then he can be found guilty or not guilty. If not, then there's always not guilty by reason of insanity. There's a guilty but insane, and so that's kind of where it is.
Yeah, so this is quite a big day, of course, as we know it, in the New Jersey case, where the prosecutor has to sort of tie it all together, all of the evidence that was presented, and refute what defense counsel is saying, because we know, and Daryl, you know this well, practicing criminal defense work, that they've got this burden of production, but the burden of proof never ever shifts to the defense. So what we're going to do now is go back in